All right, we are recording. So the title of this presentation and seminar, second time around, advice for clients when getting remarried and common mistakes to avoid. And I'm Kelly Jesson, co-owner of Jesson and Rains law firm. We're an estate planning, business, and construction law firm, and I primarily focus on estate planning and business planning, estate planning particularly for business owners because they have unique needs. And Dara will introduce herself in just a second, but we decided to do this presentation because we run into a lot of overlapping issues and repeatedly run into a lot of the same issues. And we talk about them and thought, it would be great if these things didn't happen. How can we help do that? And one of them is by talking to other professionals who also deal with clients who are getting remarried for the second and sometimes third and fourth times. And so that's why we put this together to present to other professionals, not particularly the people who are getting remarried themselves, but other professionals, so you can kind of keep these things in mind. So I'm going to turn it over to, I didn't skip the slide. I'm going to turn it over to Dara now so she can introduce herself and start talking about prenups.
I'm Dara Larson, and I practice family law exclusively. I have a law firm with my husband, which is pretty ironic because we do divorces, and yet we are a married couple with a firm, kind of like Kelly and Ed. And to piggyback onto what Kelly said, we experience a lot of issues with people where they've spoken to another professional, either a financial advisor, perhaps an attorney that doesn't do family law in particular. And then with that, they've been told certain information, they get married. In this situation, often we're focusing on a second marriage. And then they think certain rules apply and they don't. They've been misinformed. And so with that, we wanted to kind of explain to people, okay, well, here are some common issues that we see. And when someone comes to you, and Joe, you in particular, if someone's coming to you and saying, what should I do here? You have a little more advice on what to tell them. And additionally, same thing with realtors. You guys are often the first people to know that someone's getting remarried because they come to you and talk to you about trying to buy a house before they've even gotten married. So with that, we want to kind of give you some additional information on if you are experiencing people asking you questions, now you'll kind of know what to say and not put your foot in your mouth or tell the wrong information. So we're kind of focusing on things to avoid. So the first thing here is common misconceptions. The biggest things that we see are people not understanding what is marital property. And I'll get into the different types of property. But when someone gets married, how we classify property is really important, because if you get divorced, suddenly all of your estate, all of your property can be divided. And so some big misconceptions that we see, not only from laymen, but also professionals, are that if it's from before the marriage, it's definitely yours. If it's titled in one person's name, or it's in a separate bank account, or it's only in, account with one person and their family member, that it's just theirs, which is not true. Men can't get spousal support. So often we see things where no one's waived spousal support for the guy. It's just the female. And then Kelly will get on this some more, but that your will can trump inheritance laws, or that your will can trump how things are classified and titled. So for example, how your house is titled, the deed of that. Okay, you can do next slide. So for us, the biggest thing that you really need to focus on is going to be how property is classified. So we have marital property, separate property, and then kind of like a mixed commingled property. Marital property, for our laws in North Carolina, we say from the date of marriage to the date of separation. And separation is when someone actually moves out of the house. It can't be they move to a separate room. It's they moved out of the house, one person moved out with the intent of staying gone. So between those two kind of buoys is what I tell people, that's going to be your marital property. Anything in between there is going to be presumed to be marital. So for example, common ones are going to be income from employment during the marriage. A lot of people think, well, my paycheck goes directly to my separate bank account and we each divide the bills and pay for certain things. Well, no, that's not really going to be the case. Our laws say, no, any income, it doesn't matter whose account it's in, that's marital. 401k earnings during the marriage are going to be marital. Things like credit card debt. The law can be a bit complicated there, but generally speaking, in practice, what's going to end up happening is any credit card debt obtained during the marriage, same thing with mortgages, are going to be marital property. That means if your wife or your husband decide to run up a credit card, even if it's just in their name and you say, that's fine, but you've got to pay it off. Well, no, not really. If you two were to get divorced, you're on the hook for half of it. And so that's something really important to keep in mind. Separate property is when things that are acquired before the date of marriage or after the date of separation. So I have some examples here of 401k earnings from before the marriage. If you had a whole separate 401k that you had at a job you had before the marriage, then that whole 401k would be separate. A car that's bought and paid off before the marriage. A house that is bought and paid off, that there is not a mortgage on it, from before the marriage. A common example would be student loans created after the date of separation. Two parties separate, one person wants to go back to work, they take out student loans. So long as it's after the date of separation, that's still going to be separate. Inheritance is also going to be separate. That is presumed to be separate. Where we see issues are where, and this is in particular professionals because they don't understand this part, is where we get into mixed property or commingled property. So it's when property has both marital and separate elements and aspects to it. So this is where we see people, when we are doing divorces and they don't have a prenup, get into a ton of trouble because they thought their whole marriage, things were separate. And they thought they had taken all the precautions and they had spoken to their financial planner, they had spoken to an attorney and didn't realize that they didn't have the correct legal documentation in place, and that it doesn't matter what the agreement was between the two of you, the law is going to apply. Common examples, the biggest one we have is a house was purchased prior to the marriage, but there's a mortgage on that house. And during the marriage, the couple is paying off that mortgage. Well, that mortgage is being paid with the earnings you acquired during that marriage. So you get your paycheck, you pay the mortgage as part of the regular bills. That creates what we call a marital interest in that house. So where you thought this house that you had 100 grand of equity in from before the marriage is completely yours. No, that's not the case anymore. Actually, you've created a marital interest in this thing that you thought was completely separate. Additionally, if you use separate cash, such as a down payment on a house that you want to purchase, you guys sold your old house, you're purchasing a new house, and you get a pretty large inheritance. So you say, we'll put this inheritance as a down payment. Or I'll put this inheritance and then we'll use it to pay for renovations on the house. People are not realizing that then it's gone. It's either going to be completely marital or you're going to have a lot of trouble trying to divide it out because it's all commingled. Another one that's a little bit more complicated is sometimes we see student loans for professional degrees. So things like the most common example is a doctor. So doctors, lawyers, something along those lines. We can have it where since the marriage benefited and the lifestyle benefited from that degree, that we can create a marital interest in that degree, even though it would normally be separate, because everyone's making more money because you're a doctor. And that should be kind of like a shared expense. And then next slide. If anyone has any questions on that, feel free to ask now. So the big thing here is, what do you do if you want to keep things separate? A lot of people say, well, I understand that, but we have an agreement. You know, we're talking about second marriages here. I've been burned in the past. We have an agreement that we want to keep our stuff separate because I know what happened last time. The only real way you can do that is through a prenup. People have really negative connotations on prenuptial agreements and they have a bad rap, but we love prenups. That's the only way you can really keep things separate. So you might as well, if that's your intention, do a prenup. Another thing is talk to any divorce attorney, and they'll tell you prenups are great, not just for if you're getting divorced, but also just planning your marriage. It really lays out how are you guys going to handle finances? How are you guys going to divide expenses? Everything's put out there in writing, so there are no surprises. And surprises and miscommunication tend to be what leads to problems. Additionally, prenups are not just for the rich people. Everyone thinks, well, I'm not a celebrity. I don't have millions and millions of dollars, so I don't need a prenup. Well, that's not the case. Just what we talked about, we really get them a lot on people with second marriages. They thought things were separate. That was always how they had done finances for the last 15 years of that marriage. And then they find out, oh no, I'm walking away with $100,000 in debt that I didn't realize. Or I'm a super saver, the other person isn't. I thought I had all this money, now I have to give them all of my savings or half of my savings. So people have been burned, and then they want a prenup for their next marriage, just so it's very clear. Another thing that we see a ton, and probably our most common thing, would be people are doing a second marriage and they have kids. And they learn from that first marriage that half of your estate is gone if you get divorced. And so with that, they want to make sure that they have adult kids or kids from previous marriage, and they want to make sure a portion of their property is going to be carved out for those kids so that they can make sure they're taken care of, and that stepmom or stepdad isn't going to get half of everything. And next slide.
And Dara, I had some clients come in the other day with a prenup, and they have very few assets. And so at first when I saw it, I was kind of confused. Why do they have a prenup? And then I learned that they're both expecting very large inheritances. So they kind of did that proactively before the marriage because they knew that they were expecting that.
Yeah, and that's a really good idea, because if you, even with an inheritance, it should be separate. It should be classified as separate, but people don't. You have to jump through a lot of hoops to keep property income that's earned during the marriage, earned or given to you during the marriage. You have to jump through a lot of hoops to keep that separate. And people don't realize that there are all these pitfalls that make it commingled. So for example, if you know you're going to get a big inheritance, a prenup is great because it says this inheritance, no matter where we put it, if we put it toward a house, if we have to pay repairs, whatever, that's coming back to me, and it's not suddenly lost in the marriage. A great thing with a prenup, and we'll get into the estate side of it as well, but right now I'm going to kind of focus more on a divorce. A great thing with a prenup is that you get to decide how you want to and we have a question real quick. How do you keep an inheritance separate, or will you cover that? I'll go ahead and talk about it now. Inheritance. So one, obviously, ideally you have a prenup that lays it all out, but let's say someone doesn't have a prenup, you would need to make sure that separate inheritance is never put into a joint account. One, always, always, always keep it in a separate account that the other person cannot touch. If it's an investment account, that's fine, but keep it completely separate and in your name. You cannot and should not use that money, like I said, as a down payment, as something to, if you're purchasing property. If you purchase property and put both people's names on that piece of property in North Carolina, that's going to be the default. If you're married, it's going to be in the husband and wife's name by tenancy by the entirety, is what we call it. That is viewed as a gift to the marriage. So suddenly you think, well, I'm at least going to get my inheritance back. No, not really. You're not. If you're already married, it's too late for a prenup. You have a huge inheritance that you want to spend on something. You can always do what we call a postnuptial agreement. So it's like a prenup, but it's after the marriage. Why we don't love those as much is, one, it's a little bit harder. There are certain things that we can't put in there once you're already married because of public policy. But also, most of the time people don't want to sign it after they're already married unless they've cheated or really trying to save the marriage. So it's kind of hard to get people to commit to a postnup once it's already done. But yeah, you would just have to make sure that everything is completely separate and it's never at all put in joint names, or it could even be interpreted as joint. So for example, like cars or something like that, if you put it in both people's names. Yeah, exactly. So long as it's separate, it's separate. Once it's commingled, it's commingled. The issue is and I can't list them all, there are just so many small ways that you could commingle. People, when they're married, just don't think about this is mine and that is yours, which is a good thing. But there are all those little things that you do where you say, oh, we are going to pick up the car, so we'll just put it in your name, so you're going to pick it up. Well, no, that's suddenly you've gifted them a car from your inheritance. So we want to keep everything completely separate. Okay. So like I was saying before, prenups are great because you get to choose how you classify, and you can be really flexible. You don't have to say what's separate is separate, and we're not going to have any joint accounts. We're not going to have anything together. I've had people, and I'll kind of talk about this later, but I've had people that say everything's going to be separate except for I have to hit a certain income threshold. And if I'm below that threshold, then for spousal support or child support, we can put in certain income thresholds to make sure that your income only and not the other party's income is going to paying your previous family support. So that way, when you marry someone, you're not on the hook for their ex-wife's alimony. And in particular, we have a lot of people in finance, and so we have a lot of double high earners. And so that can be a real big concern. Additionally, we can carve out certain things, like, for example, the inheritance. Everything will be according to the marital laws. Everything's going to be joint in marital property, except for this inheritance, which is going to be separate. Or except for an income from an investment property that I had from before the marriage. Well, that's going to stay separate, and it's not going to suddenly become marital. Another thing would be if you own your own business, that's going to be huge. You really, really want a prenup. And if you have any partners, you definitely want a prenup, because that business, even if it's just in your name, even if you built it up, a portion of that business is going to end up being marital. And so your spouse then gets a part of that business. They don't get to run the business, but they get part of the value. And so if you have a business that has grown and grown and grown during the marriage, then that business could be worth more than any of your other assets. And your spouse gets half of that increase during the marriage. So from there, and we have a quick question. Okay, could a buy-sell agreement work there instead of a prenup? We do both. So you do a buy-sell agreement, but then we also do a prenup or a post. Sorry, real quick, the question was, could a buy-sell agreement work there instead of a prenup? What we normally recommend is you do both. And you do either a prenup or a postnup, because they have different rules. And so the buy-sell agreement is like business law. The prenup postnup is family law. And even with a buy-sell agreement, during the divorce, different rules will apply. And so what we normally tell people is, yeah, do a buy-sell agreement with your partners and the business people. That controls that side of things. But then, yeah, exactly. So with Kelly is saying that the buy-sell agreement gives the other partners the ability to buy out the divorcing partner, which is true, but we don't want people to be in that situation. And so we normally say, let's see, if the business is open during the marriage, correct? No, it can be open before the marriage or during the marriage. So someone can have a 15-year business, and we're talking about second marriages, so these are really common things that come up. Someone can have a 15-year-old business. They get married, they're married for 10 years. We'll do the math, 10 out of 25 years of that business is going to be marital. And I bet that business went up a lot during that marriage, most likely, where they've kind of like built up all this goodwill. And so then suddenly you're having to buy out that increase in business and the percentage of the marital value of that business. And what a lot of people do, small business owners, is they put all of their assets into that business. And so then from there, they don't have other assets to buy out the spouse. And so then you're looking at, are you going to have to sell your business? Are you going to have your partners buy out your interest in the business? And you can do that, but if it's something that you've built up for the last 20 years and it's your baby, then you don't normally want to do that. So that's where a prenup is really, really helpful. Often I will have financial or wealth advisors, or I even have people's partners call me and say, they're getting married, but we don't like her or him. It's a gold digger. We want them to do stuff. And I'm like, they have to call me. I can't force them to do anything. But it's that big of an issue that often we have the other partners are trying to force a prenup on the person because they've had a previous partner that it became a whole issue with. Okay, feel free to ask more questions. Is what we like. Okay, another thing what I had talked about before was going to be with kids, if you want to carve out, so often what we see, if people had a previous marriage, they know that half of their estate is gone if from during that marriage. They want to make sure their kids from that previous marriage are going to be taken care of. Because stepmom, stepdad, even if they love those kids more than anything, maybe they have their own kids, right? And we all kind of try to protect our own. So people often say, well, I want this separate property, this life insurance policy, this house, this whatever, this cash, this investment account. This is what's going to go to my kids, and I want to make sure that they can't touch it. And so that is really, really common as well. If we kind of set aside these pieces of property that can't be touched, and then we can even say, well, everything else can be joint and marital, but this particular thing is not going to be. So that's great. You can be really flexible, and you can say, for example, like just the business is not going to be marital, but maybe the income earned during the business will be counted as marital. So like if you put it in a joint checking account, well, then that's marital, but the actual business value and the business as an asset won't be marital. We can be super flexible with it depending on what people want. But these are all things that you just really need to think about, because as we just talked about, there are all sorts of things where people don't expect that their little baby business is going to be not taken care of, or that their investment account that they had during the marriage, but they also put money in during the marriage, is suddenly a marital asset or a mixed asset, and it's not going to be able to go straight to their kids. Additionally, and Kelly will talk about this some more, but prenups can be used as estate documents, and Kelly's going to get into kind of the nitty gritty of it, but this is another really common thing that we do prenups for, of people who are older in particular, or once again, trying to protect their kids and make sure that there's not going to be a fight in the family. We put different types of waivers and estate language in our prenups, and that's part of the overlap between Kelly and I, is that, and I'll talk this more after Kelly speaks, but when we do a prenup and we use the estate language, we always say, well, go talk to an estate attorney as well. And we want to make sure that these match and where everyone's on the same page. And it's not just if you're getting divorced, it's also if you were to die. And so that's a big thing to think about, is a prenup covers, well, everything is good, let's go ahead and talk about what's going to happen. Are those kids from previous marriage going to be taken care of, or is everyone going to get equal shares? It's kind of all out there. And Kelly's going to get into the nitty gritty, and then I'll jump back in.
All right, so I'm not going to read this word for word, but before we talk about the kind of the overlap, I thought it would be good to just touch on inheritance law in North Carolina. And so first of all, there's intestate versus testate. Everybody who's on the call right now knows the difference between the two. Let me just make sure we don't have a question. Good to know. Okay. So intestate means that you have passed away without a will. Testate means that you have a will. And so the differences are, intestate means that the laws of the state of North Carolina are going to govern what happens to your property. Testate means that you can leave it in a will. We have a new participant joining. Let's see, waiting, admit. Let's see, I don't know who it is, but hello, who just joined on the iPhone. And so I'm going to keep going. Ask any questions if you have any questions. This is not a full house today, so we've got time to be interactive. So intestate means that the laws are going to state who gets your property. And so what I've done is I've just cut and pasted into this slide what the real property statute says and then the personal property statute says. And if you've got this up on your screen, you can read it. It says real property, that interest is passed to real property in the following manners. And then if we go to the next slide, this is personal property. If a person passes away and they're survived by children or parents, this is the share that a surviving spouse would get in personal property. And I know that not everyone, admit, let's see if they're going to join now. I know that not everyone can see this, but I can tell you that nowhere in either one of these statutes is there any mention of marital property or separate property or combined or commingled property. And so in terms of inheritance law, my saying is, if it's in your name, it's fair game. So as Dara was saying earlier with, you know, how you would keep, you know, an inheritance separate during the marriage, you know, stick it in a bank account in your name and never, ever touch it. Don't commingle it, never touch it. Then that's going to be your separate property. Well, guess what happens when you die? Sorry, that is personal property. The money in the bank account would be personal property. That would be subject to the intestate laws. So that's a common misconception that we always have to deal with, or especially me, you know, when I'm doing estate planning, people say, oh, well, that's not marital. Like, sorry, don't care. Should have got a prenup. So anyway, so we don't have to delve into these statutes in detail, but I just wanted to show you that. Testate equals will. Again, if you die with a will, you can name who gets your stuff when you die. But there are even some catches to this, except beneficiary designations, real estate deeds. So Dara mentioned this briefly. If you have a named beneficiary on a life insurance policy or retirement, that they're going to get your stuff. If you co-own property with someone, real property, so husband and wife on a real estate deed, joint with rights of survivorship, they're going to get that property when you pass away. And so if I have a will that says that all of my property goes to Joe, but Connie is on a deed, she's not all of my property is going to go to Joe. So a will does not trump beneficiary designations and real estate deeds. So the other two things that come into play here, that's going to be the majority of my talk, is going to be the surviving spouse allowance and elective share. So even though you can name who gets your stuff when you die in a will, surviving spouses have special automatic rights under North Carolina law. And estate planners have to keep these in mind when we're doing estate planning. And it really only comes into play when there's a second or third marriage. Or possibly some separate inheritance property, you know, something like that someone wants to keep separate. But this is normally a second marriage issue, second or third, normally when there's kids involved. So let's talk about these. So first off is the surviving spouse allowance. This means that a surviving spouse is entitled to the first $60,000 worth of personal property, not including liens and encumbrances. This applies to every surviving spouse in this state, no matter if they died the decedent died intestate or testate. So if I have a will that leaves all of my property to my cousin, my surviving spouse is still going to be entitled to this surviving spouse allowance. And in fact, the very last thing on this slide down here, duty of personal representative, magistrate, or clerk to assign, this is not elective. So where the elective share is elective, this is not elective. So a surviving spouse who comes before the court will assign this property. A personal representative is required to assign this property. So what does this mean in practice? I'll give you two examples. So if I have a $5,000 bank account in just my name and a Honda Accord when I pass away, and I have a spouse, and I leave my Honda Accord to my teenage daughter, my surviving spouse will be entitled to that $5,000 and that Honda Accord because it's less than $60,000. And then I'll also give you another example, and this is a real life example. I had a client hire me, and her husband had just purchased an $80,000 car. And so, you know, that makes you think, well, can you get the surviving spouse allowance? And the answer is yes, because it depends on the amount of the equity in the car. And so the loan value on it was still really high. And so when we took the 80,000 and we subtracted the loan, it was under the $60,000 surviving spouse allowance. So she was able to get the car. And of course she has to make payments on it. So that just shows you though that it's not the fair market value of the personal property. It's the fair market value minus the liens, encumbrances, and all of that good stuff. So it's really the equity. So the elective share is the next thing I'm going to talk about. This is elective, obviously. Well, let me back up and just say kind of the public policy behind the surviving spouse allowance is the state of North Carolina doesn't want someone to die and then their spouse have no access to anything anymore, right? You know, a small bank account, a car, things like that. You know, if there's one car in the marriage, probably some of these laws are kind of maybe based in some older laws where perhaps the husband's name was on a lot of things. So that's kind of the idea behind this is when someone passes away, all of their bills have to be paid. And so the state of North Carolina doesn't want a surviving spouse to have to pay all of their bills and not have any property left. So that's why the $60,000 is before any creditors get paid. So the elective share is a similar public policy, being that the state does not want a decedent to be able to cut out a surviving spouse completely. So that's kind of the idea behind it. And as you, the longer amount of time that you're married, the more that the surviving spouse is entitled to, and that's what's on this slide here. So unlike the spousal allowance, the elective share is elective, meaning that someone actually has to affirmatively file this claim. And that's going to be the surviving spouse is going to file this. The surviving spouse has a right to claim an elective share, which is the amount equal to the applicable share of the total net assets, which we'll talk about in a second, minus the net value of property that's already passing to the surviving spouse. Okay, so the applicable share here is if someone's married less than 5 years, 15%. Someone's married between 5 and 10, 25. Let's see, chat. Is this just for NC? Yes. And other states might have laws like this, but I don't know. But this is North Carolina statute. If 10 to 15 years, 33, and then 15 years or more, 50%. So, you know, you're kind of, I don't want to say you're rewarded for staying married longer because it's still only 50%. I would like to get 100%, but that's kind of the reasoning. So what are total net assets? So this is really important too. Total net assets, if it's in your name, is fair game. So if it's a bank account with a big inheritance in there that you've worked really, really hard to keep separate your whole life, so it's not marital property, it is part of this elective share total net assets. Bummer. Also, life insurance policy proceeds. Okay, so you have a big life insurance policy and you leave it to someone. It is fair game under the elective share. Retirement, everybody squirrels away money for their 401k and their IRAs. That's part of the elective share as well. And then you subtract debts, claims, and expenses of the estate from the total net assets and then do the percentage. So I've done a real quick, easy example on the next slide. Decedent has $5 million in life insurance and he left it to his kids from a previous marriage. He died with a will, leaving his property to his wife of 7 years. His property consisted of a joint with rights of survivorship bank account worth $50K, a $20,000 singularly owned vehicle, and a $600,000 residence titled tenants by entirety. He also has a $10,000 credit card bill. And so the way that we figure this out is the top line is going to be his total net assets. So we take the $5 million, and then we also take the $30,000 car. And then we take 50% of the joint property. So that's going to be 25 and 300. And then we subtract the debt claims and expenses, and we get that top number. We multiply it by 25% because they were married for 7 years. And so that $1 million 336,250 number is going to be the total net assets. And then we subtract the property that was already passing to the surviving spouse. And that's going to be the house, the car, and the bank account. And then the number that's left is 656,250. So that is the surviving spouse's elective share. So where do you think that money comes from, that 656,000 and change?
It's life insurance for the kids.
Yes. So the only, liquid assets that are available to pay that extra amount is going to be the life insurance policy. The kids are going to have to write a check to stepmom. I'm sure they're not going to be happy about that. So this just kind of goes to show you that with estate planning, it's more than just, so Joe has a question. If the life insurance was beneficiary designated, would that not trump this? No, it would not. The kids have to write a check. Isn't that crazy? So the life insurance policy, the beneficiary designation trumps the will, right? So the money is going to go to the kids. But under North Carolina law, the surviving spouse is entitled to that percentage of net assets. And if she doesn't get it, or he, which he did not in this example, then she or he is entitled to a part of that life insurance policy. And it doesn't have to be life insurance. It could have been $2 million in a brokerage account. It just so happens that it happened to be life insurance here. But this just shows you that if I was the child, I would tell her to pound sand. Well, you know what? They do. They do a lot. But this just goes to show you that that there can be some traps here that people aren't aware of. And just going and seeing someone or using LegalZoom to draft a will might not be the best thing. If I have a client who tells me that they've got $5 million going to their kids and $600,000 going to their surviving spouse, that's an immediate red flag for me to have a conversation with them about the elective share statute in North Carolina. So how can we avoid the consequences of the elective share statute? And there's really 3 ways. There's this post-nup or spousal waiver. Dara calls it a post-nup a lot because when divorce attorneys do it, they probably incorporate divorce language in there. When I do a spousal waiver, I'm really just dealing with inheritance when someone dies. And then there's a spousal trust, and then there's a prenup. So these are kind of your 3 options. So the spousal waiver I do a lot of, and that would be, for example, the example that I just gave you with someone coming into my office and I'm like, surprise, your property is not going to pass the way that you want it to. Well, how do I make it pass the way that I want it to? Well, your spouse will have to sign a waiver saying that he is okay with getting less than the elective share. He waives his right to claim the elective share, or he waives his right to the spousal allowance, the $60,000 spousal allowance, because that can eat up a lot of property too, especially when you're talking about it excluding liens. You can get a lot of property that maybe the deceased person was planning on going somewhere else. The problem with the spousal waiver, though, is that it's voluntary. So I've definitely had clients visit me before who wanted an estate plan that couldn't be accomplished without a spousal waiver, and the other spouse refused to sign it. So that's a problem there. The spousal trust is a way around the elective share statute. What that says is that property that is left in a spousal trust for the surviving spouse counts as property that was already passing to the surviving spouse. And so what it does is it increases that number. So if we go back to this slide, this number would be a lot higher if we were leaving a big chunk of money in a spousal trust, which may end up netting this to zero. And the problem with the spousal trust, I guess there's two problems. One is you're leaving a big chunk of money to your surviving spouse for the rest of his life. And so theoretically, that money could be eaten up by the time that person dies, and then your kids don't get anything. The second problem with it is that there are rules about who can serve as a trustee. A lot of times people want their kids to serve as trustee, and that is not always able to happen. Sometimes banks have to serve, and those can be kind of expensive. So that's not without problems either. So finally, the last option on here is a prenup, which Dara's already talked about, but she'll talk about a little bit more when in terms of estate planning. But, you know, as she mentioned, she not only includes language planning for a possible divorce in a prenup, but she can also include language in a prenup that talks about what happens if you pass away. And, you know, my clients that I mentioned to you earlier who came in who didn't have any property, but they were expecting an inheritance, they didn't necessarily waive their inheritance rights because they weren't concerned about that. They were more concerned about a divorce. But for this presentation, we're talking about second and third marriages and people with kids. They probably want to incorporate some language in their prenup that talks about what happens to their property when they die. So keeping that separate property separate. And then I think the last thing I'm going to talk about is just litigation. So I just wanted to mention to you the process for filing an elective share petition. In North Carolina, it's before the clerk of court. So it's not a highly adversarial procedure before a judge and a jury. It's a petition before the clerk of court. Basically, it's a yes or no thing. There's no real defense to the claim. The only defenses to the claim are that perhaps the spouse, you know, abandoned the spouse, or maybe killed the spouse, and then they waived their right to the elective share in a prenup or postnup is the other defense. Attorney's fees are split between the parties. So even the estate could end up having to pay some attorney's fees, which would really make the kids happy. And then there's no real other options to the parties other than the elective share. So just wanted to mention, there's no such claim for that property doesn't go to her because it's not marital property. Like that doesn't exist. You know, that separate property, or that was before the marriage, so I'm going to sue her. That doesn't, there's no such action for that. So the only way that you can protect your non-marital property from going to someone who, you know, that you want it to go to is with a prenup or a postnup or a spousal waiver. It always turns ugly. You know, if a surviving spouse files this petition, the kids aren't saying like, oh, she's just exercising her right under North Carolina law. They're not going to say that. They're going to say, she's challenging the will, or she's suing us. So it always ends up turning a little bit uglier than you would want it to.
And then I'm going to jump in here and talk about, and Kelly touched on this, so I'll go quickly, but prenups as an estate document. I would say in probably over 90% of our prenups, we do include estate language in there. So we include the spousal waiver, we include an elective share waiver. so that that's not an issue. And we really like this because we want everyone to know what they're signing up for. We don't want any surprises. And I know I've said that before, but lawyers, we don't like surprises. We don't want anything to catch us off guard. So what you can do here is when things are good and everyone's like planning a wedding and happy and it's all kumbaya and we're gonna have a great life together and I love your kids and they love me and we're a big happy blended family, then they waive all that stuff. Because if you have been married for 10 years, things are starting to decline, and then you say, oh no, I'm sick, I'm going to insert my estate documents, and your husband or wife was like, I didn't like you anyways. I'm sorry, I have a train in the background. I was like, I don't like you anyways, I want to divorce you anyways. They're not going to sign a spousal waiver. If things are bad, they're not going to sign an elective share waiver. They're not going to sign a spousal waiver. In particular, if your adult children in them do not get along, the chances of them voluntarily saying, I'm going to give up my house or, this income that we've earned during this marriage so that your kids that are ungrateful and whatever can have this stuff, the chances are pretty low. At least that's been my experience with it. So we like to do this stuff really early on when things are still really happy. Additionally, what we really look at too is going to be, because I litigate and litigation is really expensive. So we look at, if things go poorly, what is the cost to litigate versus the cost to settle? And in other words, like, even if they don't have a valid lawsuit, if your family, like Kelly was saying, is having to pay for some attorney fees and having to pay to fight your spouse after you're dead, that's going to create a lot of hostility. And so what we like to do is have a prenup mirror your will. And so then that way it bolsters both of them. So the example that is just so classic is the Anna Nicole Smith, where she married the 80-something-year-old, I think he was a Coke owner and a gazillionaire, and there was no prenup. And they got married without a prenup. He dies a year after they get married, and then her and his family spend the next like decades in court until she dies, and then her family continues it on. It was just settled like 5 or 10 years ago. So with that, most attorneys believe that if she would have signed a prenup before all of this started, even if she filed something, which people can do, anyone can file a lawsuit, whether it's right or wrong, it would have been taken care of really early in a motion to dismiss or a motion for summary judgment, which is one of those things that happen right at the beginning of a case. So instead of them going on for decades, it could have been handled in 2 months. That's really important for attorney fees. You don't want, and for distress, you don't want your family fighting with your husband or wife after you're gone for the next 20 years. And so this is something where if you have that prenup that matches the will, then you bolster your claim and you're really protecting your children as well and your family. And then we have the advice for practitioners, and Kelly can kind of jump in here. I know that she has some thoughts on this.
Yeah. So, moving forward, kind of what Dara and I were thinking about when we were putting this together is sometimes we see things too late. And we're like, why did they do this way? Or, someone will come to me with a bunch of jointly owned property and say, well, I want to leave my half to so-and-so. And I'm like, sorry, you can't. Well, they never told me this, when I was doing X, Y, and Z. And so no common law marriage. Not a silly question, but I love getting that too.
I get this question like once a week. It doesn't exist.
And even too with estate planning, I mean, someone will say, well, common law marriage, like not in North Carolina, you have no rights. That's really, do what?
I was just saying most states don't have common law marriage anymore.
So anyway, we thought, well, if we just share some of this information with some professionals, maybe they'll think twice about working with people who are in a second marriage, or who are ideally it would be before they got married again. So maybe we shouldn't automatically assume that people want to do everything jointly. And maybe we should talk to people about where they're taking funds from and moving it and doing something else. So the big obvious things are, ask clients if they've ever been married before. And that's helpful because sometimes they have obligations to their ex-spouse. It's also helpful too, because they might be a little bit more sensitive to, or a little bit more open, I guess I should say, to doing some planning based on the potential for a divorce. If they've already been through one, obviously ask if they have a prenup. Their prenup might say that things can be kept separate. So then we don't want to go and start commingling things and undoing a prenup, especially for me, if someone has waived their spousal rights in a prenup, I want to know about that before I start doing their estate planning. And like I was mentioning before, future obligations. And in prenups and in divorce documents, there can be requirements that people do things in the future. And us as professionals who are working with these people, we need to be aware of those so we don't inadvertently do something that we shouldn't be doing.
Mm-hmm. And real quick, Joe had a question. So if someone had been living together for decades, unless they had joint property or accounts, big issue when someone dies. Kelly, I'll let you do.
Yeah, I mean, I guess the counter to if it's in your name is fair game could be the reverse. If it's not in your name, you're out of luck. So,
Yeah.
If you've been living in someone's house and it's not in your name, if you've been sharing a car, anything like that, unless you are married, because then you have those automatic surviving spouse rights, you are kind of out of luck.
Yeah, and that's something that right now, in particular, if people have been married before, it's very common for people to live together but not get married. And I think most divorce attorneys would tell you that can be, don't live in sin, as Joe says. That's really, really common that we see. And then it becomes this whole situation. We even have it where there's like an oopsie baby after the fact, and then they break up because of the stress. And then suddenly they're trying to get like alimony from someone along with child support. And we're like, no, you can't get alimony, or that house that's just in their name, you're kicked out of. Like, I'm sorry, I don't know what to tell you. So we have marriage laws for a reason. I mean, they're pretty important. If you feel that way, you should probably marry the person and get a prenup, because then if you're concerned, it's a win-win. So real quick because I think even the people that aren't here but that had signed up, or lose-lose, you're right, Joe, yeah. I think for the people that signed up, we had financial advisor. I think it's kind of mainly aimed at financial advisors and realtors. For realtors, I think the big thing would be you talk to people when they're looking at buying a house, and whether they buy a house before they get married or after they get married, how it's classified can have a really important, it creates a lot of issues because it can be classified without right of survivorship. So then they could give their half to their kids. But as soon as you're married, the default in North Carolina is going to be to do it as what we call tenancy by the entirety. And you have to get them to sign all sorts of waivers and free traders and things like that to not do it that way. And so what that means is that it's going to go to them automatically. So that if you were to die, it's automatically going to go to that spouse. Where you can kind of ask people along the way, like, oh, do you have kids? Do you have this? And you don't have to give them legal advice, but at the same time, you now know some of those red flags. And additionally, I get most of my prenup referrals probably from wealth managers or financial advisors or people that are partners at a business where they've been burned by it before, and they're wanting to have someone come in and at least talk to me about options. And so you guys are kind of on the front line of that. And as Kelly said, often we see it too late. And they said, well, I talked to someone, but they told me that so long as it was just in my name, it was covered. And we're like, no. And now you owe them. I just had one where they owe them like $70,000 for a 4-year marriage. And that's not ideal. Joe said, can I get the info on the elective share? New info for me.
Yeah. Yeah, we can share these slides, and then Joe, I can talk to you more in private. And like I said, it's for most people this is not an issue. So I don't even talk to people about the elective share. If they're a couple and they've never been married before, and this is their first marriage, and they say, "I'm leaving everything to my kid, to me, or to me, to my spouse, and then if my spouse dies, I want everything to go to my kids." Well, then we don't even have to have this elective share discussion. It's only when there's a second or third marriage, and especially when there's kids. It would be great if some of these conversations, not even necessarily about the elective share. I don't expect a lot of people to have a high level elective share discussion with other people, but just kind of like a, heads up that, it's not just, marital property, non-marital property, or, things like that. Talk to a divorce attorney, talk to a estate planning attorney, even real property deeds, like Dara was saying, is really important. I guess to kind of sum up, when dealing with a couple who is about to embark on a second or third marriage, the defaults that you would normally choose for a new couple may not apply. So just think about that, moving forward.
And we also, in case you're talking to people, this would apply to both of you guys. Even if we have all the waivers for spousal share, elective share, and that everybody's property is going to be completely separate, often the one thing that we will do is we'll call it the marital residence. The house that the people are living in will be joint. So that way the dying spouse does not have to fight the other person's family for their own home. And we don't like that. We normally are going to carve out a kind of an exemption there, an exception to the rule of this is the one thing that we're going to do jointly, because we don't want it where your husband or wife dies and suddenly you're kicked out of your house and or in a fight with their family. And so we normally will say, okay, well, this one, let's go ahead and put it as joint. Any other questions? Exactly. We don't want the deceased spouse homeless.
Thanks everybody for being super interactive. We're a small but mighty group. So thank you.
It's hard with the COVID, but thank you guys for coming. If you guys have any other questions, feel free to email us or call.
All right. Have a good one, everybody.
Bye, guys.